Good afternoon, everybody, and welcome to today's webinar, Reopening Amenities in the Current COVID-19 World. My name is Craig Vaughan. For those of you who don't know me, I'm the president of Castle. Castle specializes in providing management services to apartments, condominiums, and HOAs in Florida. We partner with more than 300 associations from 7 different offices, including offices in West Palm Beach and Tradition, with a team that's now 1,750 strong. Just a quick question. Rose, are we going to see Paula before we get going? Let me continue. Welcome this afternoon. It's been an interesting time. I'm sure you'll agree. It appears that we are finally seeing some light at the end of the tunnel, which is a huge relief to everybody. I wanted to thank you for your leadership. Thank you for your thirst for information. We received over 150 registrations for this seminar, or for this webinar this afternoon, and more than 100 great questions. I've reviewed most of the questions are covered in this afternoon's webinar, but as Rose said, you're welcome to continue to ask questions through the Q&A feature. I'll attempt to work those into the discussion. If we don't get to them, we'll have a little bit of time at the end, and certainly if we can't get to them then, we'll circle back with you outside of the seminar platform. Please note, if you're seeing me looking strangely around, up and down, or nodding, I'm not daydreaming or falling asleep. I am trying to read your questions at the same time as looking at my notes and listening to what guidance Paula is giving us. So please don't be alarmed, I'm fine. We are using a Zoom platform today. We did check in on the Zoom platform performance just before we got online. It's a little erratic, but we will continue to monitor that. If you happen to get frozen or can't hear, please just log on and log back in again. That's the best solution that we have to get going. And we'll do the same from our end if we freeze up. Before I ask Paula to introduce herself, I want to remind everyone that she is not intending to give specific legal advice to your association. For those questions, you should reach out to your specific counsel or your professional advisors. This is discussion regarding the reopening of amenities as we come down the other side of the COVID curve. And then we will have the opportunity to address some other issues that may be affecting your community. So before we jump into the agenda, Paula, can I ask you to introduce yourself? Good afternoon. Can I ask you to please introduce yourself, tell us a little bit about yourself and your firm.
Yes, thank you, Craig. Paula Mera. I've practiced condo, HOA, country club law for 17 years. Since 2003, I was an attorney at a large firm in Boca, representing over 1,000 associations and country clubs at that point in time for around 13 years. I then departed and practiced on my own and of counsel to another firm for about 3 years, and then landed, thankfully, at Rosenbaum, and in 2018, October, which I was very happy to do because we have a deep seat here with respect to experience. I practice with Steve Brayton, Dan Rosenbaum, our litigators. For our association department, we do like to describe ourselves as a deep seat of experience. I have 17 years, Steve Brayton has 26 years. We love what we do. We love representing our association clients. It's been a challenge during this time. I will introduce my background because that's going to be a curious question for many listeners today. This is our conference room. We have been at the office the entire time, social distancing, practicing the CDC protocols. This is the Yellow Brick Road behind us. This was actually painted by a paralegal's son. So I think today, Craig, you can agree, we're going to travel down that Yellow Brick Road. We're going to answer a lot of questions with respect to where do we go next, much like Dorothy and her crew when they went to find Oz, right, to get back home. So I think it's representative of where we are today with COVID, the ever-changing orders. Everything is coming at a fast pace. We may have to go back a couple steps. Who knows what's next?
I love your deep seat of experience. We just say we're old and experienced at Castle, but I'm going to change that vernacular starting tomorrow. So I do appreciate that that initial guidance. So thank you very much.
Of course.
For those who are logged into our webinar, we have Our agenda this afternoon includes a review of the current legislative environment, which is changing rapidly, and we'll talk about that. A framework for reopening of your amenities, a little bit about liability and risk mitigation, what's next, and then jump into any Q&A. So Paula, let's jump right in. Seems everyone is issuing executive orders, the president, the governor, the county, municipality. It's a executive order minefield is what we refer to it as Castle. We are still under the state of emergency issued by the governor that was recently extended to July 7th. The entire state is now in phase 1 of the recovery. However, every county in the state, every local municipality is dealing with this differently, and boards have to be mindful of the restrictions that impact their particular community. Again, hope this afternoon to cover all of the various local orders. Our plan will be to focus in on Palm Beach and Indian River counties, and then have a general discussion of the reopening amenities in these areas. I would note, if you're from outside of those counties, the principles of the reopening that we're going to talk about today will apply to everyone. So we encourage you to stay and listen in. Paula, can you give us an overview of the current regulatory environment, first from a statewide standpoint?
Yeah, and let's add some framework to that, because I think it's important that everyone understands there is a framework to this. And the framework is, it goes from the governor's order down to the county. And then also you may have, as you mentioned, a municipality issuing an order, which is even more restrictive. So that everyone understands that that is how it flows. Always double check, consult legal counsel as to what applies to you. Riviera Beach, Singer Island is a very good example of that right now. All the other beaches are open except Riviera Beach, Singer Island. You guys may have seen that on the news yesterday. So that gives an example of the more restrictive nature of these orders can go from the governor to the county down to the municipality. Today, as you mentioned, Craig, we're going to talk about Palm Beach and maybe North. Miami-Dade and Broward also have their more restrictive orders, or their more detailed orders that just were issued a few days ago when the governor opened those 2 counties up to phase 1 as well. The Palm Beach County is ever changing with respect to the pool restrictions. We have some questions that have popped up on the question and answer of the webinar, and that is with respect to the pools. And thankfully, I was really frustrated, frankly, having to provide advice to our clients for the pool monitoring. The pool monitoring restriction has now been reduced down to an assurance or some type of the association making sure, that's the best way to put that, that the CDC guidelines are being followed, including a posting of a notice at your pool to put everyone on notice that those protocols need to be followed.
I think that's a great point. I did read the legislation yesterday, and it's now much more specific as to who, how you're going to monitor if you have to. The notice requirement was an interesting addition. Before we kind of jump in, your thoughts on that?
The notice requirement with respect to the pool?
Yeah.
Again, this is very new, but those notice requirements are pretty specific with respect to the EO 7, Executive Order 7, which was just issued. It's very specific with respect to the language that needs to be used on that signage, and that's all users of the community pool shall abide by any and all social distancing guidelines, including but not limited to CDC guidelines, and that said users of the community pool bear the responsibility of such compliance and assume the full risk of utilizing the community pools, which is that last sentence, assume the full risk of utilizing. This is an interesting point because when we were, I'll say, stuck under that previous order, we were providing our clients a risk assumption agreement for users of the pool. We were stuck under the additional duty that was placed on our community associations under the prior order with respect to monitoring. So this particular order now removes that concern or thought with respect to liability. When you mentioned liability earlier, we were stuck between having to issue our guidance to our clients, our association clients, to either open the pool, which was a big factor for the association members. Of course, everyone was pushing, we want to go back to the pool, but yet depending on the size of your community, it put them between a rock and a hard place, because that prior order actually provide an additional duty that didn't exist before to monitor. So this new language, the new sign that the associations must place at their pool, then puts the responsibility, the liability back to that risk for the owner member to use the pool.
That's great. We're going to talk a little bit about liability and risk mitigation later, but I thought that was a huge win for associations. We are getting some questions regarding where can I find my specific ordinances or regulations, and the county websites all have great data with respect to the latest order. So I would encourage you just to go right there. Paula, what else I think is hugely important is this is changing. It's literally changed in the last 10 days, big changes from last week. It's really important, and I can't emphasize enough, and I'll do my quick legal commercial, that you are in touch with your legal counsel as you work through the reopening of the amenities, of your amenities. Just because you don't want to miss, and again, they're changing all the time, and you don't want to be behind, because I guarantee you the vocal minority in your community is looking at what it is and knows crystal clear what you can and can't open. So, get with your attorney when you're looking at a plan. I think what I want to jump into, Paul, is a framework for reopening your amenities. And I think that, it's inevitable that all of the amenities will open again. There'll be a new normal likely, but at some point, everything's going to open up again. So we think it's important that the association have a plan. So we've built a framework at Castle for, how that plan should come, what you need to consider and how that plan would come together. We're basically saying, have a plan, communicate the plan, which helps you manage the expectations of the community. They won't necessarily like the plan, but they will be aware of the plan, which we think is half the battle. So let me just kind of walk you through, if you don't mind, what we've defined, and then I'll ask you some specific questions about amenities. But the real question is, where do you start? So again, at Castle, we had a playbook for shutting down amenities. We now have a playbook for closing them up, for opening them up again. We wanted to develop a framework that can be used by associations and their boards to draft their own plan. Acknowledging that communities are subject to different regulations, which we've just talked about, physical plant limitations, i.e. the size of your pool, the size of the gym, the size of your card rooms, the demographics of your community, staffing for your community, what staff you might have available to you, and of course, the budget, your budget. Some of this is going to cost some money. So what we decided is we need guideposts. So what are our guideposts going to be? And you did a great job of cascading down the relevant regulations, but those are those create one of the guideposts. What can I open? What can I do? And the second guidepost that your plan has to fit into is, what are the CDC regulations that are being referred to? Really, in our case, specifically related to social distancing, gathering, and then cleanliness. So those are your plan has to fit within those guideposts. And then within that, we have a framework that gives you a framework. And then now I have to go down through my particular community. And what I want to do is walk through and ask you specific questions as we go relative to amenities. A lot of the questions that came in were very specific. I have a bocce court, what can I do? So the first order of business within your framework is, what amenities do I have? Pool, tennis, pickleball, bocce, gym, card rooms, craft room. I mean, they go on and on and on. So let me ask you a general question. What specifically, Paula, am I allowed to open in a community? And so let's go through the big five, which we say. So pools are initially in Palm Beach, you had the monitoring requirement. Apparently that's not the case any longer. But am I allowed to open my pool, and what are you advising your communities regarding using volunteers? Because there still are obligations, compliance obligations from the association. So take us through your guidance on pools.
So our guidance on pools as of this week is the association still needs to maintain that the CDC protocols are being followed in the pool area, which includes your pool deck. And I think for myself, when I give guidance to our larger associations, the guidance still is enable the association to do that. Again, maintaining budget, maintaining a source that you can make sure that you're abiding by the CDC protocols. Remove the pool deck furniture. While it may be great to have it at this point in time, while it's not required, because the orders at this point require the association to space that pool deck furniture 6 feet apart. And at this point now, the individual user is responsible to clean that pool furniture. In my opinion, for the association board of directors, for the association itself, our recommendation is just to still remove the pool deck furniture.
I like that.
I think the point of reopening some of these amenities, the basis is for the exercise component of that, to get fresh air, et cetera. Have owners bring their own furniture, and then, of course, still maintain that social distancing. Again, it's not required, so I want to make sure everyone understands you can space that pool deck furniture 6 feet apart, but for many associations, it's just easier and it makes more sense for them, both financially and from a monitoring perspective, to just remove the pool furniture. Outside of that, again, ever changing, where the updates with respect to the monitoring requirement, which has been removed, makes it much easier for us at this point in time to open the pool facilities. We had many clients, whether they were small or large, where it just didn't make financial sense because they couldn't put that pool monitor in their budget, or they just chose not to. So now that we have the ability to just assure that the pool is being used with CDC protocols, that makes it easier. And I believe that a lot of my associations that kept it closed will be opening. But that was our main guidance, was remove the pool furniture at this point in time, which I believe would still be my opinion or my guidance for our associations that don't want to maintain additional regulations and monitoring to make sure that the pool furniture is spaced and then quote unquote cleaned. Another big question that came up from time to time, especially for our smaller associations, was the cleaning of the bathrooms. So let's make sure that the health department still requires associations to have a bathroom with their pool, associated to their pool, close to their pool, for the pool users. So don't ignore that fact that the order didn't change with respect to having the association clean those bathrooms regularly, more regularly than they did prior to this. I've had associations close off a couple stalls where there was just 1 or 2 stalls, of course, keeping that handicap stall open. So that's a different consideration that can be made as well. So you're cleaning less, but you cannot close the bathrooms just because you don't want to clean them. Keep that in mind.
And what about, did they put in specific restrictions on capacity?
There was a capacity restriction for Broward County, which was 50%. There was not a capacity restriction for Palm Beach or north of Palm Beach. But again, to maintain CDC guidelines of social distancing, that became a question. Also, the social distancing, we all know, applies to owners, people that are not of the same household. So that's really difficult when you talk about larger associations, which have a really large pool. How do you identify who is and who is not of the same household? I've had clients that have utilized colored bracelets, but again, now you're talking about staffing and you're talking about more costs with respect to opening that pool. So if you have a smaller association to a larger association, we're talking about a lot of different factors. But the CDC guidelines with respect to social distancing in the pool and outside of the pool apply for Palm Beach County and north.
What about now, but there are still some compliance obligations. I did notice the order kind of maintain that the management company, board, association still have to make sure there's compliance obligations for these cleaning protocols and rules. Can you just quickly summarize those for us?
So the compliance obligations are, and they still remain, that the association monitor the pool to assure or ensure compliance with all of the guidelines of the CDC, the social distancing, the cleanliness, et cetera. So just because we don't have to have now a pool monitor, let's say in Palm Beach County, we still have to monitor the pool to assure that the CDC guidelines are being followed by those users.
Right. And I do have a couple of questions. I just want to, because we're talking about pools specifically, we have a question regarding ADA compliance. If you remove the chairs, is that a factor in this decision?
No, I don't think that the ADA, I don't believe, has any requirement that there is a pool chair for someone who has a disability.
Right.
You know, your disability related issues would come up with respect to accessing the pool itself, but there's no requirement that there's seating at the pool.
Fantastic. Okay, well, last question on pools before we move on. Your recommendation, and we're advocating for the same thing, is at this point, keep your furniture stacked, let people bring their own furniture, mark the pool deck if you need to set out kind of the 6-foot blocks. We have some associations that are actually, one of the best plans I've seen is an associations which is booking blocks of pool time. You have 90 minutes, 4 sets of 90 minutes, half an hour between. You clean everything, because it's not just the pool chairs, it's the coping, it's the handles, it's the bars, it's all those things. So you kind of have a 90-minute, 8 to 9:30, clear everyone out at 9:30, have residents sign up, clear everyone out at 9:30, clean for half an hour, 10 to 11:30, do the same thing. And I think that, that allows you to monitor usage, have the social distancing, clean everything. So there's lots of unique programs out there.
I agree 100%. And that's what we have been seeing with respect to, again, our larger associations creating reservation blocks for users.
Yeah.
And that's been effective. It's been helpful. That way, again, what's the alternative for our larger associations? To have a line outside of your pool gate? That's not reasonable. So yes, Craig, 100%. That's what our larger associations have been doing.
Fantastic. Okay, we'll go back to pools later, but because there are a couple more questions, but I want to move on a little bit. Tennis and not to be excluded, pickleball players. We had some guidance in the past that tennis courts could open. There were some specific rules around CDC guidelines, and then they changed, I think, to allow increased play. Can you run us through the tennis pickleball rules?
So the tennis and pickleball rule has changed. I will tell you, just from kind of a side note, when reading these orders as they were coming out with respect to the golf or the tennis and pickleball, I just shook my head, right? It's like that emoji where you shake your head, hand on the face, because they didn't make it didn't make sense. So I believe that these particular newer restrictions make more sense. There was only single play allowed. You have to use your own ball, and you should have marked it with a marker with respect to whose ball was whose. So now at this point in time, it's less restrictive with respect to tennis play. And again, it just kind of defaults back to maintaining the social distancing and cleanliness. So the restrictions are less with respect to your tennis courts. And then now, again, they've allowed doubles play with respect to tennis and pickleball.
And there are still, again, your overall guidance there, and ours is the same, is that you still have to comply with the CDC guidelines and all of those types of things. Does an association have any responsibility to monitor that?
The association still will need to monitor to assure that the tennis courts, the pickleball is not being, I'll use the word abused, that the players are still maintaining those CDC guidelines. Just in the same way that you would make sure in any, without COVID-19, that the tennis courts and the pickleball courts are being utilized with respect to the rules and regulations of the association. Now we have a different layer that we're going to make sure that there's no gathering on the side court, there's no groups gathering without social distancing, there's no groups more than 10 gathering on the side court and not playing.
It's interesting. We'll talk a little bit about enforcement later and what tools the association has, but our experience has been people get this. Like, there's lots of things they don't get. People get this to a large extent. So in our communities, we're not having to do a lot of a lot of policing because, again, people understand. Now, there are abusers of the system, of course, but that's kind of what we're seeing.
There's always going to be that one, right? But I think you're right, Craig. What I've been seeing with respect to The association, whether it's just the rules or regulations, or now with the extra layer of the CDC protocols to utilize the facilities, that individuals are maintaining a higher standard of obeying what rules or protocols they need to obey. I have found the same thing.
We do have a question about, again, just a quick question on the monitoring, and I think the answer is that you don't have to have someone standing by the tennis courts, but you want to be aware as a management company. We want to be aware of what's going on out there and helping make sure the CDC guidelines are adhered to. Okay, I'm a gym rat. Not really. I don't even like to go to the gym. I don't even like to walk by the gym. It makes me nervous. But we do have neighbors that want to go in the gym. Can we open our gym up in our community?
The gym can be opened with 50% capacity. However, at this time, if a client were to call me for advice, I would say, let's keep the gym closed a little longer. And the association is within their authority to do so. I just had an association, again, and it's a case-by-case basis, because you may have a smaller association with a small gym with very little usage, but the association will be required to maintain, again, the cleanliness, the wiping, the swiping, the disinfecting of that gym. So again, case-by-case basis, it may be reasonable and economically feasible and feasible within itself to open that gym. But when we're talking high-rise condos with a lot of usage, be prepared to staff it, be prepared to wipe it. I had a situation where we had a COVID-19 positive case. It was a regular user of the gym. I'm not going to go into any other details of that, but it was a warning to the association that A, the gym shouldn't have been open, but B, now what have we done with respect to exposure to other members? So keep that in mind when we talk about liability. There's always a causation component to liability, and I believe it'd be very, very difficult to prove causation with respect to someone catching or being infected with COVID-19 from gym use, but there's always a personal injury attorney out there. So in my opinion, until we get maybe a few months down the road, my opinion is to keep the gym closed unless the association is prepared to be very vigilant with respect to cleaning.
That's a great point. Cleaning and regulating how many people are in the gym, I think that's another big factor. And what we've found is, the gym's a huge community. The gym has a capacity for 50 people. You could have 25 in at a time. You have to clean, you have to monitor. Like, it's a lot of work for 25 people working out in your gym. I like your guidance. Maybe just sit tight. The dust will settle on this, and it might be easier later on. And your comments fit right into our framework, right? Do we have the resources? Can we clean every day? Do we have the staff? That type of thing. Okay, let's move on. Paul, I'm starving. I have a cafe in my community. Can they open, and can they feed me?
They can open. We're going to, again, maintain that 50% of the occupancy with respect to feeding. Can you do that? Go to 25?
It's 50 now.
It's 50%.
Yep.
Again, I think that my advice on this would be a little bit different, because that is an amenity that we understand that the association members are paying for. Of course, they're paying for the gym as well, but it's an amenity that the board of directors needs to consider.
Right.
To open, but you're going to open that at 50%. The bars are closed. The menus are cleaned. We have of course, the requirement, your table cannot exceed 10. So keep that in mind. The employees have to wear masks when they're serving. All of the different requirements that would apply to, of course, a restaurant on the avenue or wherever else would apply to the association's restaurant or cafe.
Right.
And
Well,
outdoor seating is recommended. I mean, outdoor seating, if you have that, is the recommended.
Yeah, I think we're in the same boat. I mean, you just listed off 10 regulations that, restaurant owners get, and maybe associations that have cafes don't necessarily understand. So there's lots of rules. In our world, we're still seeing a lot of our cafes still ran and did pickup, kind of curbside pickup, just keep some activity. That makes sense. The outdoor seating, I think, is another good one. Whether you're opening up your restaurant for 50%, use in your community is another discussion. It sounds like to me. Okay, now last of the big five is Clubhouse. Our clubhouse has been shut down for March. Can we start to open up our clubhouse?
You can start to open up your clubhouse. However, again, on a case-by-case basis, I recommend clients look at the activity that the members want to engage in. Necessary at this point in time. We are at May, 19th? So for those clubhouse activities, can we wait another month with respect to opening those, maintaining social distancing, of course, and all of the different CDC protocols and guidelines? The board needs to, and here's an important component of this, board meetings at this point in time. I've had some clients where they, quote unquote, their executive committee is moving forward to make decisions without a board meeting. I don't recommend that, of course, because you're having a board meeting without notice. While we are under a state of emergency and those emergency for both 718 and 720 statutes apply, slow the roll a little bit. At the very beginning, when everything was closed, there were a lot of decisions that were made, which I think can be justified on an emergency basis. But at this point in time, definitely have the board meeting, notice the board meeting, and have a discussion about the pros and cons of opening those clubhouse facilities to the membership.
Yeah, I think that's great guidance. And then, all of this is kind of premised on you need the plan. We're walking you the framework to come up with your plan. 2 comments. 1, get it approved by your attorney to make sure the rules aren't changing, the landscape isn't changing as you go through. And 2, you don't have to be, just because the regulations say you could open the gym, to your point, Paula, you don't have to open your gym. And right. It gets down to the next point in our framework, which what are the demographics of our community? What are they asking to be open? What gets used by 1,000 residents or 500 residents? So when you consider demographics, we manage a number of communities in the 55 and better space, and they're largely slowing down. Notwithstanding the fact that the pool's open, they're keeping them shut sometimes. They're, really doing aggressively managing the number of people who are visiting the pool. So, that's another consideration in our framework. Does the setup of my amenity provide any limitations on reopening and complying with the CDC guidelines? How do I adhere to social gathering and capacity restrictions in a small pool area, in a small gym? So again, more guidance, and you've given some great advice. Do I have staffing limitations? We talked as the pandemic was rolling out, if you will, about maintenance fees and the collection of maintenance, and everyone went, well, my amenities aren't available to me, so there must be huge cost savings. Well, there might have been some, but now we're seeing the other side of that, which is, okay, I'm going to open and I got to clean my restrooms every hour, or I have to wipe down the gym every hour, or these types of things. So there are some costs on the other side of that, and some boards, frankly, just can't afford it. On that note, we do have a question from a resident, or excuse me, a webinar participant saying, can we have a committee to do the sanitization and things like that? What are you recommending to your associations with respect to volunteers in the community stepping up to help defer costs?
Well, frankly, that's kind of a hairy area, because when an individual volunteers to assist to monitor, it came up with respect to the pool monitor,
right?
Or it came up with respect to I'll clean bathrooms and I'll be the volunteer for that. Well, that's great until something potentially bad happens to the volunteer or to someone who drowns in the pool, and we had the monitor there, where before we never had a lifeguard at the pool deck. So in those situations, what we have done is have a volunteer release form. So if someone does want to volunteer, that's our recommendation, is to have that volunteer sign a release that they are doing this voluntarily, and that there's no additional duties or burdens on the association to provide some protection from COVID-19. If they were cleaning the bathrooms, or if they somehow caught COVID-19 and wanted to claim the association was the association bathroom is where they got that. Nice. So volunteers, we usually We usually don't recommend that volunteers are used in these settings, and if they are used, we do recommend that that volunteer sign a release.
Well, like I planned this, that leads right into our discussion on liability and risk mitigation. I do want to move past the framework for reopening amenities and just conclude by saying every community is different. Municipalities have nuances in their guidelines that not a normal, you wouldn't necessarily know day to day. So, know your amenities, have a plan for each, consider the demographics in your community, consider the cost implications and your staffing. And then, run that plan by your attorney and then communicate it to the greater community, if you will, by your attorney, excuse me. So Paul, let's move on to risk mitigation. I've now partially reopened my amenities, and I've got people who aren't social distancing properly. What tools does the association have in enforcing these new guidelines?
If the association has a major issue with respect to social distancing at one of their amenities and the individuals have not responded to the association's manager or on-site property manager, then you would need, I would recommend calling law enforcement, which might result in the association as well deciding to close the amenities, unfortunately. So the bad actors are going to create a situation where the pool may have to be closed because the individuals are not maintaining the social distancing guidelines or otherwise. Additionally, I believe the association, again, we are under the emergency powers with respect to 720 and 718. Those individuals may be barred or suspended from using the amenities if they cannot maintain the CDC protocols. With respect to moving forward with additional rules and regulations, I believe it's wise for the board when they do meet to discuss those and to make sure they're properly posted, especially at our larger facilities with signage. I saw a lot of associations early on put signage up even before the pool was open with respect to what the guidelines are so that everyone's clear on that.
Well, what about I think you stated the obvious, and I think sometimes it gets overlooked, but close the amenity if you have a problem. That's the ultimate tool, right? You don't have to, it doesn't take long. It's like we always say in our world, if you have a parking problem, tow a car, then you won't have a parking problem. But so if you have, a problem at the pool, shut the pool. It'll probably, the community will step up to self-regulate is what we see sometimes. So, I think the one tool the board has is step back, walk it back if you are having a problem in your community with respect to, the rules that you've instituted. Paul, we talked a little bit about signage. It is in the new order. It's required now, but does that really mitigate the board's liability?
I believe under the new order that it does. Again, because the prior order actually imposed an additional duty that didn't exist before, which is why we didn't like it as attorneys, right?
Okay.
So this new order with the signage and maintaining some type of system or putting some type of system in place, which I recommend the board has their minutes reflecting what that system is going to be. Is it going to be, a drive-by look every half hour from the property manager as to the pool? Is it going to be every hour? Let's make sure we document that somewhere so that we understand, should something bad happen, that there's something that we have put in place as a board as far as protocol for assuring that the CDC guidelines are being followed. We don't want to be in the situation 2 months down the road and everyone's scratching their head as to whether or not the association management was actually doing something to assure that CDC was followed or not. So my recommendation is when the board meets to put the protocol in their minutes, resolve to have that protocol in place and make sure that that protocol with respect to assuring the CDC protocols are being followed are somewhere with respect to documentation that the association considered it and put it into place.
You did mention earlier about having residents sign a waiver. Can you just reiterate your kind of guidance on that issue?
Yes, we've had associations that have required users of the pool or other common, area facilities sign a risk assumption. And that's what I kind of like to quote it as, a risk assumption. You are assuming this risk, and there is nothing the association can do to reduce the risk in total. Right. So different than sort of a waiver, but it's a risk assumption. You are utilizing these facilities, and you are recognizing and acknowledging that you are utilizing them at the point where the association can't do anything more to completely reduce the risk of potentially catching COVID-19.
Right. Well, that's a risk assumption. I do like that. Paula, I don't know, do you have the order there? Because we have a number of people asking us to reference the specific new order. Do you have the number there?
It's number 7, the emergency order 2020-007.
So 2020-007 is Palm Beach, and that has the new signage and opening.
Yes, that has the new signage language. And what's great is if you just put in Palm Beach order, executive order on Google, it will pop right up.
Right.
Orders on the Palm Beach website are listed. COVID-19, I think red button at the top of their website where you can click on that, and all of those orders will be lined from the beginning of this crisis forward.
Fantastic. Thank you. Paula, still on the issue of liability, you know, the board, we're getting lots of questions. Am I liable for opening and reopening amenities? Is there increased liability to the association? 1, and 2, can you explain the business judgment rule that kind of can help the board mitigate risk?
Well, in any situation, not only COVID-19, but the board is always, the board members want to use what's called and referred to as the business judgment rule. What does that mean? That means you're going to carry out the board business, the association business, as a prudent person with the best interest of the association in mind. Not your own interest, but the interest of the association in mind. And with that business judgment rule, often what I refer clients to is, when in doubt, get a legal opinion. Right. When in doubt, get a, whatever you're dealing with. Maybe it's an engineer's opinion. Maybe it's an architect's opinion. Maybe it's some professional opinion that you as a board member and the board as a whole can rely upon with respect to what decision they're going to make, which will of course impact the association. So the business judgment rule is you're going to be a prudent person and act in the best interest of the association. But again, when the association has a doubt, or in this situation with COVID-19, reach out to legal counsel, whether it's an email opinion or otherwise. Get an opinion on what you may be doubting so that you base your decision in that opinion. And that is always almost a protective layer for our board decisions.
Right, because I think it is important to note that we've had I've talked to a couple of insurance people, I'm sure you have as well, and the feeling right now is because it's a virus, it is unlikely, damages caused by the virus are unlikely to be covered by insurance. So I think it's important the board to take these steps to kind of protect itself, because it's largely not going to be covered by insurance. I know that's a generalization, but that's kind of the case. So let me jump up to now, so I'm worried about getting sued. I opened my amenities too fast. I shut them down. The litigious society we're in. There is some protection for directors, some indemnification provided in the statutes, often in their governing documents. Sometimes there might be insurance coverage based on a judgment, if that's the case, not specifically related to the virus. Can you explain, one, the concept of indemnification in simple terms, and then how we are covered by, or a board member may be covered by, what's in the statute and what's in the governing documents?
So indemnification is really interesting. And in layman's terms, it basically means that you are protected by the not-for-profit corporation from personal liability, so long as you are acting and you haven't breached your fiduciary duty. So even though insurance might not kick in, you have the association, which would be required to cover your defense and also any judgment that may be rendered, so long as you did not breach your fiduciary duty. Okay. So, typically we'll see in the articles of incorporation, usually, or the bylaws, the indemnification clause for the association. However, Florida statute would also come into play. It's an updated statute, and it provides, again, for the same protections that your bylaws or articles would provide. Even if you didn't have an indemnification in your association documents, Florida statute would, because you're a board of director of a not-for-profit, it would come in and indemnify those particular board members. On a personal basis, again, with the defense of any lawsuit, and hopefully any judgment which was rendered, you want to make sure that you are not breaching your fiduciary duty, because at the end of the day, while your defense may be paid, and it's real specific, you may have to pay that defense back or put up a bond to be defended if there is a breach of fiduciary duty claim.
And then talk to me a little bit about D&O insurance and how that protects me as a director. And then I'm going to throw you a curveball, which I didn't pre-frame you with, but the whole concept of getting sued and your insurance not covering you because of the virus exception, if you will. Can you just comment on that?
Yeah, so D&O insurance is going to come into play if there has been a lawsuit filed against the association, individual board members, for some wrong that occurred to the plaintiff. What's great about it is going to be defense. Sometimes what's not great about it, it's going to result in a settlement that the association doesn't agree with. But the D&O insurance is why we have individual people serving on board of directors of these not-for-profits on a volunteer basis, because you are going to be covered by your D&O. Most of the time, 99% of the time, your D&O is going to kick in and cover. However, Craig, like you mentioned, this is brand new territory. We are recently learning that most D&O policies, most association policies generally don't cover viruses. So I can't tell you what would take place with respect to someone's claim that they have been injured because they caught COVID-19 at an association facility. I will say torts 101, when you sat in that first class in law school, there is something called causation. So I don't anticipate a lot of personal injury suits or claims with respect to COVID-19, because it will be really, really, really difficult, if not impossible, frankly, to claim there's some causation by virtue of that person catching it. So in my opinion, I don't see a lot of the COVID-19 concern with respect to an individual claiming they caught it at an association facility. That's just my opinion. And because the causation is going to be super difficult to prove. We did have some questions with respect to providing reservations at the pool, et cetera. Did that create more of a link to prove causation? That question came up a couple weeks ago that I thought was interesting. Maybe it does, maybe it doesn't. It's also why I don't recommend at this point in time the gym facilities are open, because that's just too much of a way to be touching everything that everyone else is touching without cleaning it every single time. So back to your original question, D&O insurance, I think, will cover most of these things that we're talking about today. I don't think that it's going to cover a virus infection. We've been told by our friends that we work with in the insurance industry that is an exception.
Excellent. That's great. That is great guidance, Paul, I have to tell you. Let's move on to what's coming next. So I think it's just a matter of time before we want to be playing poker around the table. We're not quite there yet, I don't think. Maybe we discuss that in another webinar, but I think the board, has to be thinking about what is coming next, which is the opening of the clubhouse for active participation by the members. But so I think that's coming along. What I would say is, I want to talk about visitors, and when the pandemic was building, most associations started to restrict non-essential visitors, right? Family, housekeepers, and that type of thing. What are you recommending to your boards about relaxing some of these restrictions at this point?
That's a tough question. Again, it's very case specific, talking about whether you're an HOA with single family homes and you're accessing a gate with a gate code box versus someone talking to you at a guardhouse, let's say. That's even a smaller difference. And then you compare that to your high-rise condominiums where it's a shared lobby, a shared elevator, shared hallway. For me, at this point in time, the numbers are going to tell us where we are heading. We're either going to head towards, in the next few weeks, in the next 2 weeks, I believe, we're going to have a higher indication of where we should go from here, including visitors. My recommendation for the associations at this point, again, case-by-case basis, but I think specific to our high-rise condos or condo clients that share the lobbies, hallways, et cetera, is to continue to impose those restrictions that were set. The board does have the authority to do so. And it only takes that one example where we get that phone call, and it just happened last week, where someone is COVID positive and it's a closed lobby, it's a closed hallway. They were visiting, they had a visitor from one of the counties that is, a higher impact county than us. So that goes to show you that's a perfect example. Should we have allowed that visitor? It's a significant other, so there was an opportunity perhaps to restrict visitors. And when you say essential, that's also a consideration. Who's essential, who is not essential with respect to who's coming into those areas. So the board really needs to consult legal counsel, in my opinion, on this specific issue. It's going to be case specific with respect to the setup, the arrangement of the facilities, and again, have the board minutes reflect the dialogue in a very specific manner, the things that have been considered with respect to still restricting visitors where it's a sensitive issue because a lot of the owners will be frustrated with those further restrictions. But I do think, again, depending upon whether you're a high-rise condo, the closed facility, the closed, whatever, it's something that to be considered, and it's my recommendation to consider limiting those restrictions, at least for the next 2 or 3 weeks. We're going to really see what happens when we start to reopen.
Yeah, I think across the Castle Kingdom, we're seeing very few associations really starting to even consider lifting those restrictions at this point in time, because it is too early, and it takes one case, and it would have been a shame to invest the 70 or 80 days we've already invested to step back. So I think our associations are really treading lightly on the whole issue of opening their amenities up again. Paul, I want to jump to some quick hits if we can. We have a couple of questions around meetings. I don't know about you. I've participated in more Zoom meetings than I ever thought I would in a very short period of time. Our recommendation is boards continue to meet. They can meet digitally or by platforms like Zoom. What guidance are you giving your associations?
So the guidance we give is, of course, same if not similar to yours, and that's if the board can meet via Zoom and have a level of participation that looks a lot like a board meeting prior to COVID, then carry out the business of the association through that format, and perhaps the association can then carry out business that's not quote unquote essential. So overall, kind of stepping back a little bit, our general recommendation is carry out business that is essential to the association at this point in time. We're not passing special assessments for capital improvements. We're not changing the fountain at the front entrance, et cetera. You're carrying out what's essential because the participation from the members is limited. Or at best, we still have boards that have not held their board meetings with Zoom. They're still just having the closed conference call. I do recommend for any association that's still limiting the board meetings to that, to expand, to gain more knowledge and to carry out meetings via Zoom or other formats which allow the association members to, at the minimum, listen, but at the best, be able to participate at the end at the question and answer or a speaking period that would be available at an actual board meeting.
I think your guidance early that, this stuff isn't to be, these frameworks, these guidelines, these rules aren't to be adopted by some subset of the board of directors, chatting. These are board decisions, and you're protected if they're board decisions and they're ratified and there's a vote and all those things. Is that a fair comment?
Yeah, that's a very fair comment. And I have to tell you, I've seen, again, kind of shake my head, individual board members in the frenzy of the beginning of this, making decisions, unilaterally without a board vote when it could have been through a board, meeting, even if it was a closed conference call. Please avoid doing that. Typically, I have presidents, they're trying to do the right thing. They think it's in the best interest of the association, but guess what? It's not in the best interest of you as a board member to carry out association business, to make decisions without a proper board meeting. So I've had several examples that have come back to bite that particular person because they made that decision thinking that they couldn't meet with their board and it needed to be made today. So keep that in mind as we move forward. Please continue to carry out decisions and the association's business through a board meeting and not just on an individual basis or not through your quote unquote executive committee.
Couple of quick ones. We're winding down our time. Can we legally require a resident that has tested positive to self-quarantine for 14 days?
If you have a person that has tested positive, the best thing you can do is contact the Department of Health and report that person that they are not self-quarantining. You don't want to take, I don't know what kind of self-help measures you would take. I don't know if you would board their door up and keep them in, those types of you never know, right, Craig?
You never know.
You never know what's going to happen. So with respect to if you know of someone who's tested positive and they're not self-quarantining, you do need to contact the Department of Health, and that Department of Health will guide you. We actually had that issue come up a few weeks ago. We've also had the issue come up several times where the individual reported him or herself to the association, thankfully, to say, I have tested positive. What's next?
Right.
So for the association, we have two different letters that can go out to the community at large to alert the community that an individual has tested positive. Be cautious, please. There is some legal advice. I saw an article which had recommended, it was actually in the paper, that the association has the ability to report that person by name. That is not good. Please do not do that. You're going to maintain the confidentiality of that person, whether they shared it with you shared it, giving them the information, or that you've learned it some other way. You're going to maintain and protect the confidentiality of that person. Questions come up with respect to, let's say you have 3 towers in your high-rise condominium association. You can identify which tower that person is in. You cannot and should not identify what floor they live on.
Right.
Same to the condominium buildings. Can we let everybody know that shares that quad condo unit, right, with the shared stairways and the shared handles or whatever it is? No, please don't narrow down where that person lives, because that could be, and it is personal information that should be kept confidential. That would be, frankly, where your personal injury would come up and claim against the association would come into play. So we have very specifically crafted letters that can go to the community association members that alert the membership that there is a COVID-19 positive case. Please don't ask us for further information because we're not giving it to you, kind of thing.
Right. Paula, I'm going to wind it up. I want to thank you so much for your guidance this afternoon. I just kind of take you through, you took us through the current legislative environment, specifically the new rules under the current order with respect to Palm Beach County, which is really what we focused in on. If you could not find those rules and you want them, please email us at info@castlegroup.com and we'll be happy to send them out to you. We talked about a framework for reopening the community, the guidepost being CDC regulations and best practices and the regulatory environment. Then we asked you to go through each of the amenities you have and carefully consider in the context of the demographics of my community, the staffing I have available, any budget limitations I have, each of those amenities and how you're going to open them. You gave us an update on liability and risk mitigation. Basically, yes, there's the virus exclusion. One of your policies will likely cover defense, which is good. And so there is some comfort in that from an association standpoint. We talked a little bit about what's coming. Any closing comments before I kind of wrap it up?
No, I think just my closing comments would be always consult, your management team is going to be your first resource. They're the frontline individuals dealing with this and knowing what practical protocols to put in place. Please consult your counsel if you have further questions with respect to what guidelines should be followed. And of course, we all have to stay on top of what's changing. And again, I think my takeaway point overall is the next 2 or 3 weeks is going to be really telling about where we go from here, probably the next 2 weeks. So I think everyone, frankly, I've been impressed with individuals overall, our board members, on how they're handling this. It's been overwhelming amount of time. And I thank everyone out there that's a volunteer that keeps their association moving forward and addressing all these different issues.
Well, I would add my thanks to the board members. The leadership we've seen from the boards in our communities, and the communities, their reaction has just been unbelievable in my mind. So we do want to thank the volunteers. Paula, I want to thank you for your time this afternoon and your guidance. We do really appreciate it. To everybody listening in, thank you very much. If you didn't have your question answered, we will try and get back to you outside this forum. If you have additional questions, please email them at info@castlegroup.com. We'd be happy to answer them. Again, Paula, stay healthy, and we'll look forward to catching up when the dust settles here. And to everybody listening, thank you very much this afternoon. Take care, everybody.
Thanks, Craig. Thanks, everyone.
Bye-bye now.
Bye.